Today I want to talk about Kansas versus Glover, decided by the United States Supreme Court in April of 2020. This was one of my favorite cases to follow this term because it's a Fourth Amendment seizure case that reads very much like a law school exam question. Here, a police officer was patrolling a public highway, scanning license plates. The license plate of one of the vehicles revealed to the officer that the owner of that vehicle had a revoked driver's license. Based on that information, the police officer made an assumption that the driver of the vehicle must also be the same person that owned the vehicle. The police officer pulled over the vehicle, ultimately charging the driver, Mr. Glover, with being a habitual offender of someone, in other words, someone who repeatedly has driven without a valid driver's license. On appeal, Mr. Glover argued that the police officer didn't have any individualized or articulable suspicion that he indeed had a revoked driver's license. In fact, all the officer knew was that the owner of the vehicle had a revoked driver's license and made no efforts in this case to corroborate the owner with the driver while Mr. Glover was proceeding down the highway. What makes this case particularly interesting at the Supreme Court level is that it was informed by a prior case, Delaware versus Prowse, decided by the Supreme Court in 1979. There, the case dealt with police officers who were doing random stops of motorists to check their license and registration. The Supreme Court held that this was unconstitutional because it was not based on reasonable suspicion, which is the standard put forth in Terry versus Ohio. But in doing so, at the end of the opinion, the Supreme Court explained that the outcome perhaps would be different if there was any basis for the police officer to believe that a specific motorist did not have a valid driver's license. So it's that distinction that was brought to bear in Kansas versus Glover. Ultimately, the Supreme Court held that the police officer is justified in stopping any motorist when the officer knows that the owner of that vehicle has a revoked or does not have a valid license. Now, on the one hand, this seems to broaden police power in a concerning way. But at the end of the opinion, the Supreme Court put into place a limiting principle, explaining that if the police officer in the course of his or her investigation was presented with any contradictory information, that should weigh into the reasonable suspicion analysis. For example, if the police officer scanned a license plate, determined that the owner of a vehicle had a revoked license, but also saw with that same information that the owner of the vehicle was a young woman. If the police officer in the course of pulling over that vehicle or before pulling over the vehicle saw that the driver was in fact an older man, that's the type of contradictory information that would push back on the reasonable suspicion analysis and in fact perhaps make the stop not justified for purposes of the Fourth Amendment seizure doctrine. Is also interesting because it shows us the balance that we're always struggling with in Fourth Amendment cases, particularly on something like a public roadway, where on the one hand, the state has an interest in maintaining the safety of its citizens on a public road. On the other hand, the Fourth Amendment in the Constitution protects an individual's liberty and right to be free from any unreasonable seizure or unreasonable search. Here, the Supreme Court struck that balance in favor of the state. I'd be curious to see what the implications of this are in future cases.